I would like to call this meeting of the Santa Fe Planning Commission for Thursday, November 21st to order. Can we have a roll call, please?
Ruben Mendoza. Dan Pava. Here. Jeremy Muir.
Here.
Carl Trujillo. Present. Wendy PR. Here. Erica Bowe.
Here.
And JJ Gonzalez.
Here.
You have a quorum.
Thank you. Can we all stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America, to the republic of the nation, under God, indivisible. Thank you. Can we have the approval of the agenda? Do we have any changes, Jordan?
Mr. Chair, there is a change to the agenda. Under new business, item C, the applicant has requested tabling. And that is case number 245120.
Thank you. Do we have a motion to approve?
I'll move to approve as amended.
Do we have a second?
I'll second.
Those in favor signify by saying aye.
Aye. Aye.
Do we have approval of the minutes of October 17th, 2024? I have a correction. On the minutes, on page 7 of the minutes, it says additional dwelling units be allowed on the property. That was the case we had, and it's supposed to be additional dwelling units not allowed on the property. And it was corrected the next couple of sentences down, so that was the left out a word. Anyway, we have a motion and a second. Those in favor signify by saying aye.
Aye. Aye.
We have the consent agenda. Do we have to vote on each case separately or together? Can we have a motion to approve the consent agenda? Thank you.
I'll second that.
Those in favor signify by saying aye.
Aye.
Aye. We have new business. Case number 245170. Jessica Gonzalez, you're up.
Thank you, Mr. Chair. Jessica Gonzalez, Building and Development Review Specialist Senior with the Growth Management Department. Angelo Abeta, applicant, Summer Carnes and Associate, LLP agent, request a variance of Chapter 8, Table 8-5, Dimensional Standards, Agriculture Ranching to create a 2-lot residential subdivision of a parcel of land consisting of 2 acres and a 6-acre lot. The subject property lies within the Agricultural Ranching Zoning District, which allows 1 single-family residence per 160 acres. The property is located at 0 Ojo de la Vaca, Commission District 3. The applicant is requesting a density variance on an existing 6-acre parcel and a 2-acre parcel. This variance request is being made to allow a 2-lot residential subdivision of a parcel of land consisting of a 2-acre and a 6-acre lot. The existing 6-acre parcel and 2-acre parcel are zoned agricultural. Illustrates the allowed density at 1 dwelling per 160 acres. The applicant has addressed the variance criteria per section 4.9.7.4, and staff has responded to the applicant's comments. Building and Development Services staff reviewed the variance application for compliance with pertinent SLDC requirements and found that the facts presented do not support the request for a variance to allow a 6-acre lot and a 2-acre lot to be recognized as a legal lot of record. Staff's recommendation is for denial of the request of a variance of density to create a two-lot residential subdivision of a parcel of land consisting of a 2-acre lot and a 6-acre lot. The subject property lies within the agricultural ranching zoning district, which allows one single-family residence per 160 acres. The deeds were started prior to 1981, but was not completed to be recognized as legal nonconforming. On October 10th, 2024, this request was presented to the Sustainable Land Development Hearing Officer. The hearing officer memorialized findings of fact and conclusions of law in a recommended order on this request. The hearing officer, based on the evidence presented, recommend denial of the density variance with staff's recommended conditions. If the Planning Commission finds the variance criteria has been met and recommends approval of the variance, staff recommends the following conditions be imposed. May I put these conditions into the record?
Yes.
Thank you. This report and exhibits listed below are hereby submitted as part of the hearing record. Thank you. At this time, I stand for any questions.
Thank you. Any questions of staff?
Mr. Chair,
Eric?
I'm trying to understand, the deeds were started prior to 1981, but were not completed to be recognized as legal nonconforming. Can you kind of sort through that a little bit for us? Or
Mr. Chair, Commissioners, I think that when the applicant, Carl Summers, the agent, gives his presentation, it will make a lot more of that get into light. I don't want staff to try to explain it because it's, as you can see, it's kind of convoluted.
need a lawyer?
Yes.
Thank you. Thanks.
Chairman,
Carl?
so if in this particular area with the SLDC code, if I read it correctly, it's to allow one dwelling per 160 acres. Is that correct?
Mr. Chair, Commissioner, that is correct.
Okay. And where is this area exactly?
Mr. Chair, Commissioners, this area is located near Cañoncito, as you would go under the underpass and go back into that area by the Galisteo Creek.
Okay. Thank you. Thank you, Mr. Chairman. Thank you.
Thank you. Any other questions? Mr. Pava?
Hello up there. Good evening. I just wanted to ask Ms. Gonzalez, do we have some idea of the existing density? When I looked at aerials of the area, it's pretty sparse right now in terms of given the zoning of 160 acres per unit, 1 unit per 160, or a section of land. It appeared to me that it's sparse. And do we have any way of adjudicating in a case like this the existing conditions? In other words, yes, property owners around are entitled to the one house, the one DU per 160, but in reality, if we were to draw a circle, maybe a mile around, maybe a little bit larger than that section, taking in some more areas, do we have any sense for what the actual real density is with DUs per 160 acres? Am I clear on that question?
Mr. Chair, Commissioner, I don't think I'm understanding the question.
Mr. Chair, Commissioner, this area was zoned when our zoning maps took effect. That was in the early 80s. It was our Santa Fe County zoned off. It was zoned off basin requirements. So you had basin fringe, mountain, homestead, so on and so forth. In this area, it's always maintained 160 acres. It's always been that way. Some of the areas there are homestead as well, and they've always been what they are now. We took that into effect when our ordinance was written, our 2016-9 ordinance, and it's never changed. It's been basically the same. There has in the past been a time when we were allowed small lot family transfers, which would allow you to go 1/2 the minimum size requirements, so thus you'll have smaller lots, and a lot of those lots up there are legal non-conforming lots, and that means they existed prior to 1981.
Yes, I thank you for that explanation. I'm just thinking if I were say I was flying over this area, or I'm looking at a Google-type map, aerial, and you can clearly see where what are most likely houses, dwelling units around. It seems very, very sparse. And I was just, based on what you're saying, is the actual density, for whatever reason, non-conforming, prior to the adoption of the code, it may actually be somewhat more dense than 1 unit per 160 acres in reality.
Chair, Commissioners, on this property, on the mailing list that was sent a 500-foot radius from the property, it was sent to a total of 9 people.
That's helpful. Thank you.
Thank you. Any other questions of staff? If not, I've got a couple of questions. When they created, first of all, are these 2 legal lots, the 2-acre lot and the 6-acre lot, created by quitclaim deed? Are they legal lots in the eyes of the county?
Mr. Chair, Commissioner, no, these are not considered legal lot of record as of right now.
So what is the status of the property there? Is there still 1 8-acre tract? Is that what it is?
Mr. Chair, Commissioner, on our maps, it is showing divided, but right now, land use would look at it as an 8-acre
8
lot.
acres?
Yes.
And what they want to do today is have it split into 2 lots. Is that, so it's still 1 8-acre lot with 2 deeds on it, 2 quitclaim deeds? Okay, that's the question I had.
So-
Wendy?
So on that 8 acres, do they own any adjacent property around there?
Mr. Chair, Commissioner, I am not sure if they own any adjacent properties
Okay,
around
so
there.
it's just the 8 acres.
Yes.
Any other questions of staff? If not, is the applicant here? Carl?
Yes.
You made it in time, Carl.
I want to thank Jessica and Destiny. I saw 2 cases in front of me, and I thought, oh, well, okay, I'll go over that. And then she called. I really appreciate that. Sorry to rush in here. I have a packet of documents that I'll walk through if I could hand them out to you all.
Burning my fingers.
Packet for staff would like me to give it to. Thank you, members of the commission. My name is Carl Summer. My mailing address is Post Office Box 2476, Santa Fe, New Mexico 87504. I do. I'm here on behalf of Angelo Abeta and Henry Duran. What I'm going to go through with you tonight is a story of a piece of property that these 2 gentlemen, who are cousins, inherited from their grandmother, Henry's grandmother, Rosendita, and Angelo's great-grandmother, Rosendita. You will see after you hear what happened in this, how these 2 gentlemen find themselves in a situation that they did not create and would not have been a problem but for the fact that the quiet title that actually partitioned a much larger piece took so long to do. It was started in the 70s, and it did not get a judgment entered until 1984. It was after the code was adopted that this order came down that split the property into the 8 acres. And then I'll tell you what happened. Mr. Abeta is a disabled individual. He lives on Social Security in California. He is from New Mexico, has lots of family here, but he moved out there for his kids. This is the only asset that he has, the 2 acres. Mr. Duran is his cousin. I don't know if Mr. Abeyta was able to log on through the WebEx. I gave him the instructions, but he had a family emergency with one of his children this afternoon, and he was going to try and log on and introduce himself to you. But let me start with, Mr. Pava asked a question about this property and where it is. It is up on the Glorieta Mesa, and the area that surrounds it is you go down through Cañada Los Alamos, go under the freeway, you go down into the area where the Galisteo Creek has, the railroad goes right by it. Mr. Pava asked about, as you all know, that's a pretty densely populated area with lots of lots that are 2.5 acres, 5 acres, 10 acres, and it goes up and down the railroad, and that's not far from this property. This property is actually up on the mesa, and Exhibit A shows you the county's aerial, and it is fairly rural, as staff has said. So how did this all come about? Let me get my glasses so I can read. Exhibit B is the property deed into Rosendita Abeyta, and that is Mr. Abeyta's great-grandmother. And the parcel we're talking about is tract number 2. It's an 80-acre tract that was created by this deed, as you can see, in 1975. So Rosendita got 80 acres as a result of this deed. Title was not clear to that property, and so she had to bring a quiet title action against various individuals and persons, and she started that in 1979. Exhibit C is the final decree in that case. And as you can see, the case number is SF79. It is a final decree, and beginning at the bottom of the second page of that final decree, you'll see this language. It says, "It is further ordered and adjudged and decreed that B, plaintiff shall grant by warranty deed to Maida E. Duran and Martha A. Jones as tenants in common a single tract of land containing 8 acres." So this decree created that 8-acre parcel out of the 80 acres. So there was a contest as to the title of that 80 acres, and I think one of the family members said, "I have interest in the property." The court divided it into 72 and 8, and that was in 1984. As you can see, 1985. The last page was signed by Judge Art Insignias on the 17th of December, 1985. At that time, and I think today still, this would have created a lot that the county recognized as a lot created by a judicial decree. And it was after, I guess, a fairly hard-fought quiet title action. So what happened next? Maida and Martha were sisters, and they were supposed to share in the costs of the litigation. And what they ended up doing was splitting the property between them. And how did they do that? They just simply exchanged quitclaim deeds. So they were both entitled to the property, Martha and Maida. Martha gave a deed to Maida for 6 acres, and Maida gave Martha a deed for 2 acres. That's what created the split. So when was that? Those deeds are Exhibit E, not Exhibit E. If you go to, I included them, they're on Exhibit F. Those are the 2 deeds that they exchanged, and you can see the dates on them. They're that year, that same year that the quiet title was finalized and the partition came out of that. Those 2 deeds were exchanged in 1985. So from 1985, this property has been sitting there divided, not legally, we admit that. So what happened next was Maida passes away, Henry is her son, he ends up inheriting that property. Martha passes, no, just the 6 acres. He got Midas 6 acres as out of the estate. And Angelo inherited the 2 acres, and they've been sitting there since they passed away. These people passed away, and it was since 2014, and they've been paying taxes on them, and they're not legally recognized, but they pay the taxes on them. So this was a problem that they inherited, not something that they created, but for the fact that this lawsuit took so long, this property got divided. These people, these 2 individuals, don't have the same plan. What could be done on this 8-acre parcel today? Let's say it's a legal lot of record for 8 acres. What could go on there today is a single house and an accessory dwelling unit. So you could have basically 2 houses. What we're asking is that Mr. Abeyta and Mr. Duran be able to have their recognized legal lot and restrict it to 1 house without a dwelling unit, without an accessory dwelling unit, and 1 house without an accessory dwelling unit, and that will not result in more density than would otherwise be allowed. So you all have the authority to recognize this, and I'll go through the criteria, as legal lots, and you have the right to restrict those and condition your approval on no accessory dwelling units, because what would end up with, you could have a house, a guest house, and a house and a guest house. That would be 4 units. We're not asking for that. What we're asking is that Mr. Abeyta be able to sell this property, as it's the only asset he has, and allow him to recoup some of the costs that he's had in paying the insurance, taxes, and going through this process. That's what the case is about. So if you look at your criteria for a variance, I believe that this is a case, many times people come in here and they say, well, we want you to divide this now and give this to my son and give this to my daughter, and we've already done that and that was wrong. This is a case in which these 2 individuals inherited this problem. And the solution that we've come up with doesn't violate the spirit of the code. I'd like to go through the criteria with you just briefly. It's in your packet. And the first criteria is where the request is not contrary to the public interest. So what is the public interest here? We have an area that is zoned for 160 acres per unit. That's agricultural generally. It's rural. Under the old code, it was based on I think the homestead zone and that sort of thing. This lot, however, would have been recognized under the old code. It would have been recognized 8 acres. And what would happen there today would be a house and a guest house. So is the public interest being violated by allowing these 2 gentlemen to have 1 house and 1 house with no accessory dwelling? I submit to you that it does not violate the public interest. In fact, it's in keeping with what the public interest would allow today under the code. The next criteria is where due to extraordinary and exceptional situation or conditions of the property, the strict application of the code would result in peculiar and exceptional practical difficulties and exceptional and undue hardship to the owner. That's an important one in this case. Why is that? This is an extraordinary and exceptional circumstance. It arises out of decades of activity, one by the court and then by people who are long since gone, and now these people have inherited it. That's not something that happens every day. It is exceptional, and it's extraordinary because these 2 gentlemen didn't have anything to do with it. The strict application of the code would create practical and exceptional difficulties. These gentlemen can't do anything with their property. They can't sell it. They know if anybody goes to buy one or the other of the lots, they can't come pull a permit. In fact, that's how this came about. Mr. Abeyta, who is admittedly running short of funds, he's living in an apartment in California, close to his kids. He's running out of money. That's what's prompted this, is he went to sell his lot, and the buyers, I think, discovered, well, this doesn't look like a legal lot. And in fact, that's when they came to me and I said, it's not a legal lot. The only way for you to do something is get a variance. Mr. Duran can't do anything, and Mr. Abeyta can't do anything. The only thing that will happen is it'll get inherited, the problem will be inherited by Mr. Duran's kids and Mr. Abeyta's kids, and they'll be in the same situation, and this property will never be used for anything. And I don't think that's what the purpose of the code is. It creates a very practical difficulty and a very undue hardship for these two gentlemen, Mr. Duran and Mr. Abeyta. The last criteria is so that the spirit of the SLDC is observed and substantial justice is done. So what is the spirit of the SLDC in this particular instance? Under these facts, the SLDC would recognize an 8-acre tract. That's in keeping with the SLDC. So what is not in keeping with the SLDC is if they each had a house and a guest house. That would not be in keeping with it, and that's not what we're asking for, and we're asking that if you see fit to grant this variance, that you restrict it to only one dwelling unit per lot. The final question of whether substantial justice is done. So really, that's a fairness question for you all to ask. What is fair under these circumstances? That usually asks you to say, how did the problem get created? Did the applicants have something to do with the problem they're now complaining about? You know, that's self-inflicted. You see that a lot when people come in for a variance. They say, yeah, well, I created this problem. Now I'm asking you to forgive me for it. That's not the circumstance here. And I say that because substantial justice is about fairness. Is it fair to have these two people who are cousins inherit this property and be able to do nothing with it? Or is it fair to have them be able to do something with it that doesn't give them any extraordinary privilege that others would not enjoy if they just had an 8-acre parcel? I submit to you that the criteria that the spirit of the SLDC and substantial justice can be done with the condition that you limit the number of dwelling units to 2 dwelling units with no accessory dwelling units. I submit to you also that, you know, I know there are a lot of factors that you see, and I have not emphasized, and I'm not going to emphasize, that Mr. Abeyta is, you know, he's basically destitute. That's not the reason he's here. He's got to be able to do something with this property. And I think it's only fair that he be able to do something and that Mr. Duran be able to do something and that the next generation doesn't inherit a useless piece of property. And I submit to you that's what this case is about, a problem they didn't create and inherited, and you all have the ability to make it right without giving some extraordinary privilege to these individuals. I'd stand for any questions you have. I don't know if Mr. Abeyta is, can anybody tell me whether he was able to log on?
I am not seeing him online.
Okay, he had a problem, an emergency with one of his kids, and I sent him the instructions, and in fact, he had, you know, one of the stops, he was able to log on, but I think he's got problems with his kids. And I'd stand for any questions you might have, but that's what this case is about, and that's what we're asking for.
Thank you, Carl. Do we have any questions of the applicant?
Mr. Chairman, yeah, thank you.
The other Carl.
Okay, thank you, Mr. Summers. So help me understand this. In 1981 is when the county, is that when the county places restriction on one home per 160 acres?
Yeah, it was. You'll recall that the county's initial ordinance was based on a water study. And that water study showed that in the center of the county around Santa Fe, that's where the basin was. And then away from that was a basin fringe. And further out from that, there's less water. So in the basin, there's more water, higher density. The basin fringe, still water, but less density. The homestead was out in the plains area where they didn't have much data about specificity of water. Clearly, the Galisteo Creek has water on it, but the county zoned this whole area in 1981 homestead based on the availability of water. The SLDC doesn't do that. It's not based on water availability. It's based on just strictly Euclidean zoning, which is just they assign a number to it, and it's not based on the water. But that's what happened in 1981.
So, Chairman, Mr. Summers, so what allows an individual to put a home currently on, if it was to remain in an 8-acre lot, is because of the SLDC code, or what allows them to do that if it says one home per 160 acres?
Because under the SLDC, there is a grandfather clause, and it says this, listen, if at the time of the adoption of the SLDC in 2015, 2016, you have a condition that was legally created, we will recognize that under the SLDC. It's called a legal non-conforming use or division. And in this particular instance, the decree in 1985, out of the 1979 lawsuit, divided this property. The court ordered that it be divided, and that, under the code at the time, would have been recognized as a legal lot. They could have come in even then to get a home on an 8-acre parcel, even though it was zoned 160 acres. It's what's known as a partition. So that's how it happened. It was legally created in 85 by that judicial decree. In 2015, the SLDC said, look, if it was legally created, it's recognized here. What was not legally created in 1985 was that exchange of deeds between the sisters. That was not legal, but the 8 acres was legal.
So, Mr. Chairman and Mr. Summers, I'm looking at the county, on the off of the assessor's page here, and I'm looking at the lots around this, and there's almost, as far as I can tell, no lots that are 160, very few lots that are 160 acres. So
Yeah,
every one of these lots, it's 20 acres, or they would have, this would be the provision, they would be able to be allowed to put a home and a guest dwelling.
Correct.
If they went.
On that Exhibit A, you'll see how there's only one lot that is a quarter section. It's to the adjoining.
Yeah.
In this quarter section, you can see 1, 2, 3, 4, 5, 6, 7 lots in 160 acres. They were legally created, those 7 lots, but they're not 160 acres. And then adjoining, you can see the Rivera family divided these 4 lots. I mean, that's a 80-acre tract. They divided that into 4. So 20-acre tracts right next door. Now, they're legally non-conforming. And I'm not saying, hey, they got it. You know, that's not my argument. But you're right. There is, as a general matter, there are not a hell of a lot of 160-acre parcels out there in this area.
Mr. Chairman, that's all the questions for now.
Thank you. Any other questions of Mr. Summers? Eric?
Thanks very much. Carl, thanks for the tangled history. I'm trying to understand a couple potential futures. If we and the BCC were to deny this request to allow this split of the 8 into a 6 and 4, 6 and 2, I'm sorry, math. If we were to deny that request, the existing 8-acre parcel could be sold as a recognized legal lot of record. Is that correct?
That is correct.
And so the other question I have is, I'm also looking at the very handy assessor's parcel map property search tool. And I'm wondering, are there access easements to either the 8 or the 4 from any of the adjoining parcels? I'm wondering, if a buyer were to come in and be interested in one or both or either of these parcels, is there a way to get there?
The answer is yes. The court decree that you have there required that in that 80 acres, along the northern boundary of the 80 acres is a county road, county-maintained road. And it goes to the...
Rancho?
Yeah, it goes to the northwest...
Rancho Romero?
Yeah, it goes to the northeast corner of that 80 acres. And from that point, there is an easement down those 80 acres that was created by this court decree. So there's
a dirt track there, I
There's
see.
a dirt
Okay.
track, and there's an actual legal easement to the tracks.
And so utilities could be brought there as well, if there are utilities up there?
I think that there's power up there. I went up to the property to see it, and I did see a transformer, and believe it or not, I think I saw a phone line.
Okay,
Yeah.
there you go, on the road, yeah.
The-
Okay, thanks very much, that's what I was wondering. And I'm just wondering, are you a client of both of these cousins or
I-
either of these cousins?
I represent both of them. I have in the packet, I was required to get the authority to file this application on behalf of both of them. I will say this, it's an awkward position because these two gentlemen are not close. I'm putting that mildly. And the problem that we have is, yeah, if they both got together and said, hey, we're going to sell this property, and they said, well, I'll take, 1/4, you take the other, 3/4. That would be a solution, but we don't have that. One party says, I'm not going to sell. I'm never going to sell. I don't care if you can never do anything with it. The other party says, well, I would like to sell. So what we've got is a situation where they're at odds, and one party has a great deal of leverage over the other party. So that's where we're at, and I'm just being frank with you.
No, thank you. That's it. Appreciate it.
Jeremy, you have questions? Oh, Dan, yes.
Mr. Sommer, I just want to say for the record, it's the first land use case I've heard described as a proverbial white elephant. I read the documentation, and I think that aptly describes what you're trying to convey to the commission.
Thank you. I didn't want to reuse it, it was in the record, but when the king gave somebody a white elephant, it was their burden to take care of it for the rest of their life, and you could not get rid of it. And in this situation, they can't get rid of it.
Carl, I've got a couple of questions. Are there any improvements on that property? Is it just a vacant piece of property, 8-acre piece of property?
It is vacant. It has the road to it, as Mr. Abo described, and it has a fence around it. It's fenced. No structures, no improvements.
And what would it take to get infrastructure or utilities on that property, like a well? Is that very expensive?
I'm not sure. Just the numbers for wells these days are going up and up, and I don't know the answer to that question. It would be the cost of the drilling of the well and equipping it. The power is close by.
The other question I had, you're a very good lawyer. Now, is there a way that you convince one of the individuals that is their best interest to sell this property without having to try to get variances or anything like that? How can that be? How can that happen?
Well, the reason I'm here is because it didn't happen, and it's probably not going to happen. And I wish that I could wave a magic wand and say, why don't you guys, work this out? And I can't, and it's not possible. And Mr. Abeyta is in California and not really in a position to do anything about it locally. Mr. Duran is here in Santa Fe.
Yeah. The other question I had is, you mentioned that if this can't be resolved by a variance, who are the heirs that stand to inherit this problem?
Mr. Duran's children and Mr. Abeyta's 2 children.
And are they young or are they adults?
They're adults.
So they would have to deal with this. And for some reason, to solve the problem for everybody, it would be a solution to the alternative would be to sell the property, either to one person or to put it on the market to sell to anyone.
The real problem that is presented in the scenario that you're talking about is it gets more complicated as the generations go on, as we all know. It only takes one person to hold out saying, I'm not doing anything. I'm not, and that's what's going on now. The next generation, I believe there's going to be at least 4 people dealing with this problem. All it takes is one person to say, I'm not doing anything. And I don't care what you do. And it would be different if all of these people owned all of the property, because you could go to court then and say, Judge, we can't agree on what to do. We want you to partition the property. And in this case, it can't be divided. We want you to sell it. And the court could order a sale. But because of the circumstances here, title to the 6 acres is in one party, the other party has the 2 acres. There's no case they can take to court and say, judge, make him sell. There's no grounds for a partition. That's one of the sticky things about this, because if it was that they both had an interest, one or the other could do what you suggested. We could force a sale, but we can't here.
Yeah. The other question I had is, you know, to grant a variance, you know, a financial hardship is not a condition for granting a variance. You mentioned this is a financial hardship on Mr. Abeyta. You know, a variance is supposed to deal with some feature on the property. And what you explained is not a feature on the property, it's just something that affects the property, which makes it difficult. So that's the problem I have is
The feature I'm talking about is that it's been divided, and that the ownership has been divided in this fashion. And generally, there are, I'm not saying that the reason you should grant this variance is because of a financial hardship. It's just that nothing can be done with that land, and that's not in keeping with, you know, general principles of fairness or property law, not being able to make reasonable use of a piece of property.
well, thank you very much, Carl. Carl?
So, Mr. Chairman and Mr. Summer, I guess the comment that I want to make is, from what I take from all this, is the best argument, at least in my opinion, is that that 8-acre lot going through Santa Fe County, they would be able to grant a home and an accessory dwelling, so 2 homes. And so you're representing both clients here on both tracts of land. And if I understood correctly, you both have accepted the condition, if this body chose to, that each one would just place 1 home on each with no accessory dwelling in the future. So hence, you'd end up getting, now, I understand an accessory dwelling is half the square footage, but basically you would end up still getting 2 dwellings on this 8-acre parcel of land. I mean, and 2 dwellings on 8 acres is not very dense. I mean, it's still a lot of land around. So that's what I see as an argument, as a solution. Obviously, there's other solutions, which is hopefully you get family members to agree today and maybe in the future, but maybe you never do. And maybe the land always sits vacant at that point. And so after looking at the final decree and seeing that there is access to this property, because I was very worried that there was not access, but I did read through the final decree that there is access. But ultimately, you're going to get the argument is that you'll land up with the same exact density of homes on this 8 acres if those conditions are attached to this.
Correct, and I think you've captured it exactly.
Okay. Thank you, Mr. Chair.
Wendy?
That property is owned by the Lynch family, and the Lynch family bought the property from Rosendita, and they bought the 80 acres there, and they also bought the 160 acres to the north. So Lynch owns that.
Any other questions of Mr. Summers?
Yes, one more question.
One more.
Did have any of the neighbors protested this at all?
No, and we sent notice out to the people that we were required to, and we posted the sign.
Yes, Mr. Pollock?
Mr. Sommer, in reading the staff report and the applicant's comments addressing variance criteria, specifically whether or not the variance may be in the public interest or essentially not contrary to public interest, could we infer, or in your opinion, is it reasonable to infer that when the judgment was made, that was in the public interest at the time, when the land was divided the way as it is today?
I think that the code, in recognizing the ability to recognize a partitioned lot, took into account the judicial ability to divide property with a partition. So that statement in the code back then recognized or defined that as part of the public interest. Because it adopted that rule. It could have said, and I think today a partition lawsuit does not get you anywhere under the code, the SLDC. they've changed that rule. I'm looking at Roger because he knows this probably better than I.
Thank you.
If I might, Mr. Chair, go into a little more detail on that particular issue because three of you have specifically asked questions regarding the 8-acre tract and the sale and/or the development of that 8-acre parcel. And the county takes a slightly different view than does Mr. Summer on one particular issue when Commissioner Abo inquired whether the 8-acre parcel could be sold and developed, basically whether that is a legal lot of record. And I'm not convinced that the answer is a definitive yes to that. In fact, the county would probably, at least initially, take a contrary view. As you probably know, the definition of legal lot of record, assuming there isn't a subdivision plat approved by the county identifying the individual lots, we then look to pre-1981 filings, any recording that shows the existence of whatever lot is in question. And as the evidence has shown, this 8-acre parcel, although the quiet title lawsuit was initiated in the 70s, the final judgment came about in, I believe it was 84, and our initial conclusion would probably be that that does not qualify the 8-acre parcel as a legal lot of record. The county does not recognize, as Mr. Summer just clarified, quiet title, or more likely, partition lawsuits can divide parcels into smaller parcels that don't meet zoning standards as far as acreage. The assessor's office will acknowledge the court's ruling, and it will even identify, let's assume, 2 parcels where there had been one for purposes of taxation. But the growth management and land use departments will not necessarily recognize those 2 smaller parcels as developable legal lots of record because they may not meet zoning standards. And that same issue could well arise with respect to the 8-acre parcel, even if it were to be sold or if they attempted to develop it jointly. And I just wanted you to be aware of the position the county takes on these issues.
Thank you.
If
Mr.
I may.
Chair, could I follow up to Roger? So Roger, if I understand correctly, the county would potentially contend that the 8 acres is not a legal lot of record. However, if this variance were approved, we would magically make the 2 smaller parcels legal lots of record. So there's some kind of sleight of hand in there, isn't there?
Well, yes, your conclusion is correct. Mr. Summer may be aware of factual circumstances that I'm not aware of that buttress the argument that the 8-acre parcel is in fact a legal lot of record. I'm not aware of that, but yes, your statement was accurate.
I will add, I've been practicing here since 1986, doing land use law in Santa Fe County, and the code and the land use department recognized partition lawsuits as legal lots of record. The SLDC does not. It does not, and that's why I submit to you it's a legal non-conforming. It's not jumping sleight of hand. We're not leapfrogging over something. And I respect Mr. Prusino. He and I worked together probably is that long. He's been here longer than that. But I was doing that, and I've personally had several cases in which we had decrees of partition that were recognized by the county under the old code. Now, the old code undertook a lot of revision from 81 to the early 2000s and then into 2015. But I would submit to you that the code at the time recognized the partition lawsuit as a division and it created a legal lot.
One person is paying taxes.
Correct, and has been. Yeah.
So, Mr. Chairman and Roger, that's what I was going to get to. I did pull this up, and they're both assigned a UPC number and a parcel lot number, so presumably the county assessor is sending them out statements, and they've been paying taxes on this as an individual lot, or piece of property.
Well, as two individual lots, I suspect. Yes, I think that's right. As I say, assessor's office will recognize a court's ruling. A court's ruling is binding, but the courts can't change the law. And if the law says a parcel needs to be a certain size, and it's not that certain size for development, these people, whoever we're talking about, owns a parcel that is recognized for taxation purposes, but is not going to be developable. That's why we try to get council to always communicate with the county when they pursue partition lawsuits, because this can come up. And I'm not contradicting Mr. Summer regarding pre-SLDC circumstances. I am referring more to SLDC interpretations.
If I may tell you, just, it goes to what Mr. Abo said. Let me tell you one of the reasons that they changed the law with respect to partition lawsuits, both in the city and in the county. The zoning ordinances recognized partition lawsuits. And what people were doing was they were getting together and saying, let's file a partition lawsuit and we'll divide it. It wasn't really a lawsuit. It was just them getting together and saying, let's divide it. We'll file a lawsuit, we'll stipulate to a judgment, and we'll divide it, and then we'll take that to the city. I didn't do that, I'm telling you, but it was being done, and that's what gave rise to the change in the law, both at the city and at the county, is that was being abused. And it was not really a partition lawsuit, it was just a friendly division using the courts. That's why it changed. That's why it changed.
So, Mr. Chairman and
Yes,
Mr. Summer, that brings up an interesting point, right? Is that they don't allow it now because people take advantage of it, or can take advantage of it. Now, do I believe two older sisters in 1980 or 78 were behind the wall there thinking, oh, let's do this
Right.
partition lawsuit and we'll circumvent the system? I don't believe that was their intent back
Right.
then.
It was a lawsuit that went on for, I think, 7 years. So it was a real lawsuit.
Thank you. Any more questions of Mr. Summers?
And, they can't sell or use their property.
Yes, that's, Mr. Eric.
One more. Mr. Summer, is the party interested in selling the owner of the two or the six?
He is. He is.
Thank you. That one actually has a higher assessed value than the 6.
If there are no other questions of the applicant, this is a public hearing. Anyone from the public wishes to speak for or against this case, please step forward. Raise your hand. Anyone? Jordan, anybody online?
Mr. Chairman, nobody's indicating they wish to speak online.
Okay, so if we don't have anybody to speak on this case, I will close the public hearing. And what are the wishes of the commission?
Mr. Chairman? Oh.
Yes, Carl?
Yeah, I'd like to make a motion. I know this is a very unusual case for sure, like mentioned, a white elephant case. I do not believe that these two ladies were scheming behind this. They did go through a proper channel, a proper lawsuit. I don't think the density would remain the same if it was left as this 8-acre lot. It sounds like there is some question still legally about even the 8 acres, but maybe there'll be another lawyer involved to help them out at that point. But I would like to approve the variance of case 24-5170 with the restriction of no accessory dwelling units, that each parcel could only have one main home, and no more subdivisions.
I would second that.
Thank you. Is there a second? Wendy? Mr. Pava. Do we have any discussion on the motions?
I would just, Mr. Chair, I would like to, again, reference what was stated in the record that Mr. Summer said when he addressed the variance criteria as supporting Mr. Trujillo's motion.
Thank you. Any other discussion? If not, what are the wishes of the commission? Those in favor signify by saying aye.
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 No.
No. How many noes do we have? Can we have roll call vote, Karen? There was one no?
Mr. Chair, can we just do roll call vote for the record?
Okay, thank you. Karen?
Pava?
Aye.
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 No.
Aye. Thank you. The next case that we have is case number 245190. Matthew Sanchez applicant. Is Destiny Romero here? Thank you.
Thank you, Mr. Chair and Commission. Destiny Romero, Building and Development Review Specialist. Matthew Sanchez, applicant, requests a variance of Chapter 7, Section 7.17.4.3, no build areas. The property is within the traditional community zoning district. The site is located at 43A Ojito Drive within Township 20 North, Range 9 East, Section 20. The applicant met with staff to submit his variance on August 5th, 2024. The applicant is requesting a variance of Chapter 7, Section 7.17.4.3, no build areas. The applicant states that he received a grading permit February 25th, 2013, with no knowledge of the permit expiring. The applicant received a notice of violation from Santa Fe County Code Enforcement on April 4th, 2024. The notice of violation was issued for no development permit, terrain management, and was issued a stop work order. The applicant states that he graded 1,200 square feet of 30% or more slope disturbance. Applicant has a revegetation plan, which includes reseeding, fiber wattle rolls, and installation of a retention pond. The applicant has addressed the variance criteria, and staff has responded to the applicant's comments as contained in the memo. On October 10th, 2024, this request was presented to the Sustainable Land Development Hearing Officer. The hearing officer memorialized findings of fact and conclusions of law in a recommended order on this request. The hearing officer, based on the evidence presented, recommended that the applicant's variance be denied. Building and Development Services staff has reviewed this request for compliance with pertinent SLDC requirements and has found that the facts presented do not support the request for a variance. Staff recommends denial of the request for a variance of 30% disturbance of slope, Chapter 7, Section 7.17.4.3, no build areas. There are alternative buildable areas on the property that contain 0 to 15% slope. If the Planning Commission finds the variance criteria has been met and recommends approval of the variance, staff recommends the following conditions be imposed. Mr. Chair and Commission, may I enter the conditions into the record?
Yes, you may.
Thank you, Mr. Chair and Commission. If the Planning Commission finds the variance criteria has not been met and recommends denial of the variance, staff recommends the following conditions be imposed. Mr. Chair and Commission, may I enter the conditions into the record?
Yes, you may.
Thank you. I stand for any questions.
Do we have any questions of staff? Carl?
Mr. Chairman, yeah, the map that was sent to us, this came from staff, right? Is that correct?
Mr. Chair, Commission, that is correct. That was an exhibit that was added today.
Okay. And this topography here is from the different grades of just that lot and a few surrounding lots, is what I see here. Okay, thank you.
Mr. Pava?
Thank you, Mr. Chair. On the exhibit that was just passed to us, I'm looking at the scale. Is this an accurate scale? The 1 inch represents 60 feet, or at least the 1 to 720. So if, and I ask that because I'm looking at the area that's been highlighted as the approximate location the applicant graded without a permit. And if I were to eyeball it, I'm guessing that we have, even allowing, just assuming it's the red area, which is about half of what's inside the twirly white line, I'm guessing that's over 14,000 square feet. Can you comment on that? I'm a little confused as to how much the lot has been disturbed.
Mr. Chair, Commission, the box that's outlined as, or what we clouded, that is the approximate location. We're focusing really on the red, which signifies the 30% slope that was disturbed.
Mr. Chair, Commissioners, just for clarification, whether or not it was entirely the 1,200 square feet, the fact of the matter is they did disturb it by pushing over the cut that they did on top into the 30% slope as well.
Thank you.
Please repeat
Would you repeat that, John?
Mr. Chair, Commissioners, what they essentially did is the entire top portion where they graded may not have been entirely 30%, but because of the fact that they graded and pushed the excess of dirt onto the 30%, that's disturbance and noted in our ordinance as well.
Thank you.
Mr. Chair, and Commissioner Pirard, they essentially pushed the dirt onto the 30% slope that's there.
Do we have any questions of staff?
So this area in the white here, that's level.
Mr. Chair, Commission, that is correct.
The whole thing?
Eric?
Yeah, Mr. Chair, again, I'm looking at the assessor's parcel map. It's a different lot. It's not it's 43B, not 43A. There's a dead flat, and you can see it above your clouded area. That is dead flat up there. The clouded area, it does not appear to be recently graded. Yeah, I'm looking at and I'm not sure if Matt has the ability to show it to everybody, but I'm just trying to understand what happened. 43B, according to the county's, the assessor's parcel map property search, 43B Ojito Drive has what looks like a sand putting green. It is dead flat, it has some rocks placed on one edge, and 43A appears not to be recently disturbed. There are small juniper and things like, so
Mr. Chair, Commission members, so 43B was actually a permitted lot that did get a permit for grading for residents. The white box that is just indicating, just depicting the location. The current aerials that you're seeing aren't accurately showing what was actually graded. I believe there are photos that were taken that are part of the exhibits.
okay, got it. Yeah, I'm looking at the counties, which might be a year older. And so this grading occurred about when?
More recent.
Mr. Chair, Commission, applicant was given a notice of violation on April 4th, 2024.
Got it. Thank you. Sorry for the confusion.
Thank you, Destiny. Any other questions of staff? If not, is the applicant here? Please step forward. State your name for the record and be sworn in.
Good afternoon, everyone. My name is Matthew R. Sanchez. Yes. Matthew R. Sanchez, 49 Ojito Drive, Espinal, New Mexico, 87532. I approach the chairman and provide some additional documentation.
Yes,
So before I get started, I want to clarify this map that was provided by Santa Fe County. That bubble in white is larger than the area that was disturbed. The two mountains or hills that are still there are located on the north and south side of the property. This bubble encompasses that. Those two areas were not disturbed. I'll start by indicating this piece of property is located approximately 5 miles north of cities of Gold Casino, going towards Espanola. It's located in Ojito Drive Estates. It's an HOA, approximately 262-acre subdivision. This is a slope analysis map that I got from the county. This information is not readily available to the public, okay? This is all Ojito Estates. As you can see on this particular map, not just on this particular map here, but you can see all the 25 to 30% grades throughout the whole entire subdivision. This subdivision is made up of hillsides, eroded areas, arroyos, and vice versa. Within this particular subdivision, the HOA has a 30-foot setback from every side of the property line. So right off the bat, you're dealing with 30 feet from every edge of the property line. You're also dealing with existing residents. If those existing residents have wells, they have septics, and this particular lot that I had already permitted it in 2013. However, me personally made an assumption that it was still good. The permit itself does not have an expiration date on it. And for the record, this is the permit that was issued to me in 2013, okay? This is the permit where you're seeing that leveled sand area. That's my son's partial. He constructed a house, and this is his permit. They're practically identical. And this one's 2013, this is 2024. There's already, a house is probably 85 to 95% complete already on that leveled lot north of the one that is in question. One thing I want to note for the record is I did post it. I put multiple notices. I sent 8 letters out to all neighboring residents within the general 500 feet. I even went above and beyond, went out 800 feet. And I had no concerns that were brought up. Nobody brought up any issues. I further went to the extent and met with every landowner and homeowner within the subdivision and got their consensus indicating that what I did and what I plan on doing does not impact in any type of negative fashion. Let me go back, and the reason why this particular piece of property was leveled probably almost 2 years ago, okay? The reason why I got a notice of violation on 4/4/2024 is they had already leveled my son's lot, which is right adjoint to it. And the piece of equipment was sitting on the property that I own. And this particular piece of property is a 5-acre tract, okay? Prior to anything, any notice of violation or anything like that, I was in process of doing a family lot split for my daughter, she's in right here, my daughter, my son-in-law. While getting that done, then that's when I got the notice of violation. So everything got suspended. So I adhered to Santa Fe County's requirements, stopped everything I'm doing. I met with multiple members of Santa Fe County, got some additional documentation. I also asked the question, because I had never seen a soil slope analysis map from Santa Fe County until 4/4/2024. And my question is, where can I get that? And the answer to me, that's not readily available to the public. So right off the bat, that's a big concern to me. And not only for me as a lifetime Santa Fe County resident, but other residents throughout Santa Fe County. I mean, this information should be public knowledge. I shouldn't have to pay $26 to get a map. And also, I've owned this property and approximately like 17 acres throughout that subdivision that I paid for probably the last 25 years full assessed value on this property. I never knew anything about any type of no-build zones, okay? And on that day, on 4/4/2024, it was communicated to me when they provided me this slope analysis map that that was a no-build zone, okay? I was unaware of that. And I'm sure, and for just to give an example, within the last 2.5 years, I bought in 2 parcels of property in there, additional, because I also live in this subdivision. And I also live on that eastern edge of the ridge of that subdivision. And based on this particular map, when I built this house in 1999, I'm on a 30% grade. And so is the other 4 houses along that southern ridge. So with that being said, I lost my train of thought there. I was in the process of doing this family last bit. I paused everything due to the fact, but one of the concerns that's brought up to me is I've been paying full assessed value on these properties, this particular piece of property in question, and I was never aware of any no-build zones. I made assumption, and shame on me. I'm not here to point fingers at anybody. I'm just here to try to go forward and identify what I need to get to go forward for my daughter. I'm not doing this family last bit or anything else for financial gain, for my personal gain. It's to assist my family. Because I think everybody in this room has family members. You want to help them as much as you can. But at the end of the day, I'm not here I'm asking for this variance due to the fact that I did level that piece of property, due to the fact that I did not want my daughter to put her house on the lower level of the property due to the fact of the drainage. There would have been a 30% grade behind that house. I drastically reduced the drainage and the velocity, the flow of water by leveling this, okay? So this particular piece of property is at the same level as my son's property, the one located directly north of that. The house located north of that one is on the same grade. The house next to that one is my house. It's on the same existing grade. I'm just saying here, there's been a set precedence in the past. I would a little bit, it's my understanding that this 30% grade requirement, and I'm learning all this now, okay? I'm not a developer, I'm not building houses, but I'm learning by this process here. I've never been in front of a courtroom. I feel like I'm on trial the first time I went out. And I'm no attorney. I'm just a native New Mexican trying to provide for my family. So I'm here asking for this variance. Some of the things that I want to point out, I gave you an attachment here. Look through those photos. You can see where the first photo is the lot itself. You see how it's leveled. You can see on the top right corner, that's the hillside that's still existing. When you go to the next page, you can see that other 2-story house in the background, which is at the same grade. You can also see that other existing hill that's there, that was not disturbed. The area disturbed was in between both those mountains, and like Mr. Lovato mentioned, that material was pushed forward onto that 30% or 25% grade. I mean, whether it was a true 25% or 30% grade, this was done by LiDAR technology. LiDAR technology is not 100%. If you go to the following page, like I mentioned, it's almost been 2 years that this piece of property has been leveled. You can see the minimal erosion that's taking place, okay? All the property directly west of this, either myself or my family owns. And when I say my family, I'm the legal trustee of my father's property, which he owns down at the below, as well as multiple lots that I own as well. On the next photo, you can see where I furrowed the property to also assist in the erosion control as well. As Destiny mentioned earlier, I want to revegetate it. I want to stabilize it more with wattles. I want to put a retention pond. I want to do everything that I can to protect the property and surrounding properties around it. But for the record, the property downstream, I own. The next photograph, it kind of gives us an overlook of the subdivision. Highlighted in yellow is the piece of property in question. The next photograph, which says additional aerial views, you can see 1, 2, 3, 5, 6 with my son's house. You can kind of see this, where they started the footing of that house, located directly north of the property in question. But those are all built on that eastern ridge of the subdivision. If you go to the next photograph, you can see, I mean, the beautiful, as I would say, $1 million views. I mean, it's optimal views. I think everybody that would have owned this property would want to try to take advantage of that. The last one, as you can see, like I mentioned earlier, I'm contending with a 30-foot setback around the whole property. Also, I'm contending with septic systems which are already existing from other property owners, as well existing wells. So I not only have to abide by Santa Fe County requirements, NMED requirements, HOA requirements, but the engineering office on where I can put a well, where I can put a septic. For the record, I have already had a development permit and approved well permit to install a well on this permit that's already been doubled. I think that's all I have. Let me just make sure I want to go through these notes real quick. One thing I want to note is that when I bought these two previous lots, and it's not the lots in question, I asked the question previously, how do people know, how do potential buyers know about this soil analysis at 30% grades? And the response I got is that they work with the local realtors, okay? I bought in 2 pieces of property within the last 2 years from Sotheby's, one of the well-recognized realtors within Santa Fe County. And neither one of those purchases indicated that I had a 30% non-buildable grade. But I still bought the properties not knowing that. Okay. Second of all, there's 2 pieces of property located right now currently that are up for sale. And I reached out purposely to those 2 realtors and I asked the question, is it all buildable? And they all told me yes. And I go, is there a 30% grade requirement that you can't build? And the answer to that, what do you mean? So there's a mechanism that I think that we, as the commission, Santa Fe representatives and so forth, this is something that needs to be fixed for the future to prevent something that's what happened to me and what could potentially happen to others in the future. I want to, for the record, indicate that I did do my due diligence in the past, in 2013, but through trials of life and changes in life, I did not commence any type of grading and or development. We're in like 2022, I did grade that area. I'm not here to argue that I didn't. I did do that. I made an assumption that there was no expiration. Another recommendation that I made to Santa Fe County is to clarify this in the future, we should have an expiration date on these permits. That way there's no ifs, ands, or buts. I mean, if I saw an expiration date, I'm in the wrong. I can't argue that. But at the end of the day, I did have a permit, I did do my due diligence, I did go get a well permit, and also filled out a development permit, which was approved. I mean, I was attempting to dot my I's and cross my T's, but I want to submit to the commissions that I want to go forward. I appreciate your support in this. Whatever you guys decide, I will adhere to, and I believe that's all I have for this evening.
Thank you, Mr. Sanchez. Do we have any questions of the applicant? Jeremy?
Mr. Sanchez, just for clarification, there is no building where you graded currently, right? It's just graded and that's it?
It's just grading use, that's correct.
Okay.
You have any other questions? Carl?
Thank you, Mr. Chairman and Mr. Sanchez. I appreciate the illustration of the existing homes and the wells and the septic tanks, because I know that they won't let you do that unless you have the 100-foot setbacks. And it actually puts it in perspective. It almost looks like a more planned out neighborhood than what it even seems like, because people have respected that.
Mr. Chair, could I mention one thing? One thing that I also got to mention, this HOA in every 2.5 acre lot parcel has to have a minimum house size for the main dwelling as well as for the guest house, a minimum house square footage. So if I put a house, my daughter puts a main house and a guest house, that also limits your overall footprint.
So, and Mr. Chairman, and Mr. Sanchez, I'm not here to like narc anybody out, but I'm just looking at the map that, I mean, I didn't get to see the big map, but I'm seeing the smaller map, and I'm looking at lot 39, and you see the red around that house. I would presumably believe that this was actually probably leveled off in the same fashion that was leveled off at these other lots, because you can see the perimeter of the 30% around it. And so I'm not sure when these other people built their homes, but even in pulling up the county maps, it seems like it's kind of been a standard there. If you look at the topology of the neighbors next to it, they're all along that same line, all the way down where it looks to be at the higher point of that property. So this isn't something that's never been done here. It seems like it's actually the standard here. Now, turn the page, you got this developmental permit, or you bought this land before the Sustainable Land Development Code was adopted, right? Because you said you got this permit in when?
Yes.
When did you get the permit to grade originally, or when did you purchase the land?
I've owned the property almost for, I would say, 17 to 18 years.
Okay.
I got the permit in 2014. I mean, I built my house in 1999. There's houses that have been previously built within the last 6 months, and I'm not here to point fingers at anybody, but they fall in within that 30% grade, but they were allowed to construct a facility,
Okay.
a home site.
So, Mr. Chairman, if you don't mind, can I ask staff a question at this point?
Yes, you may.
Okay.
Destiny?
so-
Destiny or who, or Jordan or Roger?
Roger, or if this came up on a case once before since I've been here, and it was somewhere out where there was 50 acres of land, there was a 30% slope. They're putting the house, they wanted to put the house somewhere in, but the slope was, 100 foot in each direction because it was a 50-acre parcel of land. So I went to go look at the Sustainable Land Development Code in the no-build areas. And it says, no build area shall be identified on any plat on any site developmental plan. No build area shall include areas with natural slopes of 30% or greater. So, obviously we amend code and we amend laws all the time, but if I read this, it doesn't give a general area of land. You can find a 30% slope within 10 square feet of almost any piece of land. If it's not completely flat, if it's rise over run, if some land slopes down here because some water flows across, that's a 30% slope. And so if I read this correctly, it doesn't give a mass of area or an area that 30% has to be on. And so how do I rectify this code to determine when we apply this and when we don't?
Mr. Chair, Commissioner Trujillo, we take it on a case-by-case basis. There's certainly, when you do a survey or you use topography from the county, you have incidental occurrences where it could be a drainage, it could be a pile of wood, it could be a stack of brush. It may not pick up the topography from a LiDAR perspective. So staff has to attend those sites. In most cases, in most all cases, the applicant does come in, we do meet, we stake out the site, and we identify that site, and the determination is made there on site. The administrator has, which would be land use staff, has the authority to grant alternative buildable areas in those cases as well.
Okay. Thank you for that. Well, Mr. Chairman,
Thank you.
I understand that somebody buys a piece of land now, and they go to the county to do a developmental permit, and this is now, they know this. But this gentleman purchased this land, and it's not you guys, I'm just giving the circumstances here. This gentleman purchased the land 19 years ago and got a grading permit before the Sustainable Land Development Code was even present at that time. And so was there, I mean, that's the circumstance here, is that correct?
Mr. Chair, in some instance, yes, but in the previous code, which was the Land Development Code, adopted in 1981, amended in 1996 to to incorporate the terrain management regulations, it basically was the same rules in effect there.
Mr. Chair and Commissioners, I also do want to note that Exhibit H is the exhibit for the permit that was pulled in 2013. You will notice that on page 3 is the site plan that was submitted for the permit, for the grading permit, which on page 2, staff has identified on that left side of the area as the area of grading work approved via the permit 13-69. The area to the right is the approximate location that the applicant actually graded without a permit. So although the applicant did pull a permit, it may not have known that there was an expiration date. He did not develop in the area that he was initially permitted for.
Thank you, Dominic.
Can I respond to that comment?
Yes.
For the
you may.
record, for the previous hearing that took place on October 17th or 18th, it stated on record that that area that where they're questioning whether I develop it or not was not disturbed. And it's noted for on the record.
Thank you. If no one else has questions of Mr. Sanchez, I've got Jeremy.
I didn't catch that last part that he said. Can you repeat that last part, Mr. Sanchez?
So this particular permit here, it was submitted, but he's indicating here that it's not the exact location of where it was disturbed at.
Right.
But where it's indicated on the map was not disturbed.
I've got a question, Mr. Sanchez. You pulled out a permit, a grading permit in 2013.
Yes, sir.
And what was your intention for that grading permit? What did you intend to do on that?
To level
Was it
to level.
grading a road or something?
Grading a road and leveling.
And as a result,
And
it
the reason,
seems that you did not grade the road, you graded a building site, a buildable site. Is that?
so there's an easement road that was already developed with the previous owner. So I improved the road, and then that general area where that permit was, I was to level, which I never leveled. I leveled a different area due to drainage concerns.
And that was,
And
that was in 2013. That was like, 9 or 10 years ago.
So with all due respect, Madam Chairman, I'm a military veteran. I've served multiple tours. I was not there readily available every time on a continuous basis. So I never really had the time to commit. Well, life changes. I've had medical issues with my wife, went through multiple kidney transplants, so that wasn't my priority of doing any type of development at that point in time.
And when did you resume working under the 2013 permit?
2 years ago, sir.
2 years ago. That was in like 2022?
Yes, sir.
Okay. The other question I have is, staff mentioned that there's other buildable sites that you can use, that you own. Is that feasible?
So this particular lot is going to be subdivided into a 2.5 acre parcel. As I mentioned earlier, it's for a residence and a guest house. And then with the challenges I have with existing wells, septics, 30-foot setback around the whole property, it limits my footprint of where I can put any type of structure. And not only that, if I place it in another alternate location, for the first part, I'm gonna have drainage concerns. I'm gonna have flooding concerns. And not only that, I'll be limited to only put one structure on that property due to the fact that if not given the variance approval, I can't do nothing with the property that I already leveled.
And the other question I had, you submitted a revegetation plan. Now, what was that plan for? On what lot did that plan occur?
This was this particular 43B, and that revegetation plan was to restabilize the graded area, the hillside, as well as install a retention pond, as well as put wattles at the bottom to prevent any future erosion. But I was told to suspend all activities, so that's what I did.
Now, was that revegetation plan submitted to the county for their approval, or did you go ahead and do that on your own?
I did that on my own.
Now, they mentioned that you needed to have engineered plan for erosion control. Have you contacted a civil engineer for any kind of a plan to
No,
submit to the county?
at this point in time, no, sir. No, Commissioner.
Okay, those are the questions I have. And I think, Mr. Sanchez, this is a public hearing. Anyone from the public wishing to speak on this case, for or against, please raise your hands and step forward. Do we have anybody? If not, Jordan, anybody online?
Chairman, there's nobody online indicating any wish to speak.
Okay, as a result, yes.
Just one more statement, and just for the record, all the property directly west of this, myself and my family own. So if there was any potential impacts, it would impact me, the owner. But
Okay.
I'm doing everything I can to prevent that anyways.
Okay, thank you. I think you're very sincere in your presentation, and thank you very much. We close the public hearing and bring it back to the commission.
Thank
What
you.
are the wishes of the commission? Yes, Carl?
I'll make a motion to do pass the variance of case 245190 with the staff recommendations, the conditions 1 through 7, as recognized as conditions.
Thank you. Do we
I'll
have a
second
second?
it. I'll second
Mr.
it.
Pava? Was that a second, Mr. Pava? Oh, yes. We have a motion and a second. What are the wishes of the commission?
Aye.
Signify by saying aye.
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 The variance is approved. Thank you, Mr. Sanchez. Yes.
Happy Thanksgiving.
In case number, 245120 has been tabled. Do we have petitions from the floor? Any petitions? I see none. Communications from the commission members? Yes, Mr. Pava?
Can staff give us an update about the battery storage facility and what's happening with that? I know there were some public meetings which occurred. Are we still on track for early February?
So there is a current public hearing for the hearing officer scheduled for Wednesday, December 4th, which is a special meeting. And then we have double noticed this. This will not come to Planning Commission until February 2025. I believe the date on that is it February 3rd?
February 3rd, and the meeting will start at 1:30 p.m. and it'll be at the convention center.
Will you be serving lunch?
That's why we're doing it after lunch. We will provide snacks and drinks though, because more than likely, the hearing officer hearing will give us an idea of how long it's going to be. It'll be at the convention center.
The hearing officer meeting will be starting at 9:30 or 10 o'clock in the
Okay.
morning.
Do we have communications from the attorney? Roger?
Nothing for the commissioners other than enjoy your Thanksgivings.
Thank you. Matters from the land use staff?
There are no other matters. We covered them under the AES.
Okay, thank you.
Oh, I guess I do have one question.
Yes.
Hearing officer has requested that we do not have our normal hearing officer in December due to AES. Is that going to be the same wishes of the Planning Commission? Because that will be 2 meetings that month.
Okay.
I don't need an answer right now.
So the
Just think
request-
about it. So
I'm sorry,
here,
can you repeat the request of us?
so hearing officer has requested to cancel the regularly scheduled hearing officer hearing in December due to AES. And so I don't need to know today, but by the next meeting, I need to know if y'all are okay having 2 meetings in 1 month, or if y'all would like to push.
In February.
In February. If y'all would like to push and not have the regularly scheduled meeting in February because we're having a special meeting. So I don't need to know today. I
The
just need
chair
to
is
know.
fine with it because he's termed out, but
Yes. well, whatever land use staff recommends, I think we're in agreement.
Yep.
Do we have a, next regularly scheduled planning commission meeting is December 19th, 2024. Is that still on, Jordan?
That one is still on.
Okay. I call this meeting adjourned. Thank you. And thank the staff for all their hard work.